recorded and we will distribute it. We have a capacity for about 500 folks, and we think we're close to that. So just keep us posted. And we can have you submit a poll question. And I think maybe Tom may throw that out there, but we may play with that as well. So without further ado, let me just get quickly started and talk about the fact that, we still as an industry are guided by antitrust rules. You and those of you professionals that have been in many meetings, you hear the typical antitrust statement, which says that we don't talk about specifically what our companies do, and we don't plan to do things collectively and all those kinds of things. So consider this your antitrust warning, and I will stop if I see something that gives me great pause, and I'm sure you will too. We're all professionals here, and we know how to conduct ourselves. My name is Lisa Miller, and I am Florida's former Deputy Insurance Commissioner. And I get to work with each of you every day, sometimes by phone or email, or you'll just call me and tell me something odd or fun or interesting that's happened. My particular interest, of course, is in my pro bono consumer advocacy work, talking to policyholders every day, all day a lot. Insurance agents, others that are walking and talking every single day and helping insurance companies keep their promises to their policyholders. Whether you're a vendor and you're serving insurance companies and helping on the claim side, whatever you do, know that I personally appreciate what you do. You in this industry know that once you get property insurance in your blood, you never leave it. And that's a good thing or a bad thing. So without further ado, I'm going to turn it over to Tom Diana and let him introduce himself, and then he'll pass it on to Mike Monteverde. I've known these gentlemen for a long, long time, and I respect them tremendously, just like so many of our other defense lawyers who have been in the trenches with me and others to make sure that Florida is a great place to do business, to help a lot of Floridians and their insurance needs. Tom, over to you.
Thank you very much, Lisa. My name is Tom Diana. For those who don't know me, I'm a co-founder and principal partner in the law firm of Zinober Diana and Monteverde. My partner is below me, who will introduce himself as well. I am in St. Petersburg, and Mike is in San Francisco today, so lucky him.
Good morning, everybody. As Tom said, I don't know if I've fooled any of you into thinking I'm actually in San Francisco. I'm actually in my house. But good morning. I'm also a partner with Zinober Diana Monteverde, and I work out of our Fort Lauderdale office, handling all kinds of matters and basically everything that comes across our desk. And hopefully Tom, Lisa, and I can provide some insight as to some of the things going on with the new Senate bill and some of the things and some of the impact that it may have going forward.
Perfect. Tom, I think you're doing our audiovisual aid, so we'll let you start with what you think is most appropriate for getting us kicked off.
Me? I thought that was your job.
Oh, do you have the bill you want to queue up, or
I do, Lisa. I was just teasing. Okay. I can share the screen, and if you'll just guide me on particular places you want
to. I will. So as Tom is pulling up Senate Bill 76, for those of you who do not routinely look at legislation, what you're seeing on your screen right now, the first page, the first 2 or 3 pages, all the way down to the bottom of page 4, is called the title. See where it says a bill to be entitled at the top of the first page. All these introductory phrases, every piece of legislation that you see will have what's called the bill title, and it gives you sections of the law that are amended by the following pages in the bill. So I'll let Tom get down to the bottom of page 4 and looking at line 115, and we'll start there. And if you just want a quick reference, pages 1 to 4 are what the various sections of law that have been changed. Also understand when you see underlined language like you see here, that's brand new legislation, amending in this case on line 117, 489.147. So chapter 489 is the roofing statute. For those of you that read statutes, I have no life and like to do that every now and then. And this particular section was aimed at roofer licensees. And so when you take lines 117 and Tom we won't go all the way through it right now, but it goes all the way to line 180. It talks about some of the prohibited practices dealing with roofers, which affects the Department of Business and Professional Regulation. I know Tom and Mike have looked at this particular section, and I think it's going to change some of the practices that we're seeing. When I talk to consumers, a lot of times they'll call their insurance agent and say, someone just knocked on my door, what do I do? My motto is, those that you know come to your back door, those that you don't know come to your front door, just don't answer your front door. Nice motto to keep, and I suggest that you may want to advise your customers of that. But Mike, we'll start with you. When you look at these prohibited practices on the roofing side, what do you think it will temper some of the zealousness of our roofers? Maybe have roofers on the call, some of them that are interested in doing the right things. I know we have some public adjusters on the call, and many of those that we work with, that want to do the right thing in their own professions are very interested in doing it correctly. And I think this bill particularly gives that perspective. Mike?
Yeah, well, I think that I think a lot of this bill is initially aspirational, and I think that the hope is that it will ultimately have an impact. We know, and I think those of us who are kind of in the trenches in Florida dealing with a lot of this are aware of the fact that these types of solicitation activities are ongoing, they're widespread, they're rampant, they're happening everywhere. And it's actually one of the ways that, it's one of the reasons why we've had this huge influx of contractor-based lawsuits. We know that there are roofing contractors and other contractors going door to door, handing out flyers, giving rebates, promises of gift cards. We've all seen it. We've all seen the advertisements, and this is meant to curtail it. The question really comes down to enforcement. But ultimately, if you can get some measure of enforcement of this provision of the statute, then ultimately you should probably see some kind of a decrease in some of these claims, because we all know who practice in this area and who see these claims. We know that a lot of these claims probably wouldn't exist were it not for this type of solicitation, this type of advertisement. So it's a really good attempt at this, and I think we're all kind of crossing our fingers for purposes of protecting the market. I think we're all kind of crossing our fingers that it does ultimately work, and it does work to curtail some of these claims, because it's something that we really need.
Tom, any perspective on this particular section of the law, the new
I'll
law?
echo Mike's sentiments, and just a couple of things for those of us who've been around for quite a while. We probably remember that there was a 2-day restriction on solicitation as a result of prior legislation that was struck down by the Florida Supreme Courts. And I'm wondering if there will be a similar legal challenge with respect to this particular portion of the bill. I think, obviously the target market, or the what I consider to be the unscrupulous roofers who go door to door, the front door, as Lisa indicated, in hopes to, give you a free inspection. And lo and behold, after every free inspection, there are severe roof damages that you need to report to your insurance company. There's a couple of things within the bill specifically that I think are worth pointing out. And one of them is, contrary to what we've seen following the storms, beginning with Irma and thereafter, with respect to a lot of those roofers I mentioned. And that's, submitting a bill for the actual costs or the usual and customary fees associated with the work to be performed. We're not seeing that as a result of a lot of the litigation that probably many people on the webinar today are dealing with as well. But Mike and I have seen that, for 3 years, in the hundreds, if not thousands. And I think this bill is a good step in the right direction to deal with some of that by having roofers submit the actual reasonable customary fees for roofing work to be performed in response to a legitimate claim, and not simply gathering groups of homeowners who never go onto their roof and trust a roofer to advise them as to whether or not a storm may have damaged their roof.
And let me also give those of you listening some perspective as well. Chapter 489, as you know, is under the auspices of the Department of Business and Professional Regulation. Nothing is to prevent any of you listening to call DBPR. The Secretary is Julie Brown. Certainly work with Mike, Tom, and I to guide you on how to reach them and all that kind of stuff. But I'm a big believer in managing upward. So, or if you've got a local DBPR office in your region, go into their offices. The offices are open again, and ask them, how should I, as a practitioner, work with this particular statute? And if I see these infractions, or I have consumers that see these infractions, what would you suggest that we do? There's got to be an implementation or enforcement, as Mike referenced, of this particular section of the bill. I don't know how many of you ever worked with DVPR. There's a new secretary there, and I hear she's very balanced and wants to work closely with industry partners. So I, again, encourage you to get engaged. Chapter 49, read it, understand it. If you have a local DVPR office, take the bill with you. Don't be surprised if those in those offices don't know this bill has even been signed and currently sitting in law. We're hoping that perhaps DFS, Department of Financial Services, and DVPR will team, because there's another section of the bill that talks about solicitation as well that affects the public adjuster statute. But without any further ado, let's go on to line 185. So line 185 is the new data link, claims data collection piece of the bill. And you'll notice it says beginning January 22, there shall be this collection of data, and it shall be filed with the office, either line 188, on an annual basis in conjunction with other reports that are due. And look at line 190, the report must be on a form prescribed by the commission. The commission is the Financial Services Commission. A form is a rule in state government parlance. So this form will need to be adopted by the Office of Insurance Regulation, or, shall I say, drafted and sent to the Financial Services Commission, which is the cabinet, to adopt this form for our industry partners to use to file this claims data basically on closed claims. Here's some questions about it, and I'll ask for Mike and Tom's perspective. What should that form look like? Do many of you on this call want to reach to the office and suggest, forms rule the world? Tax forms, every form you've ever had. Expense forms when you're traveling. You know what I mean when I say forms rule the world. This form is going to govern the industry's life in terms of what they collect, how it's collected, the interpretation of the various components of this section of the law. So no, it's coming. And of course, there's a question, or is it closed claims prior to January 1, 22, and then the closed claim data is reported after January 1, or is it closed claims after January 1? A lot of unknowns. Again, nothing to prevent you or colleagues to reach out to the Office of Insurance Regulation, volunteer to be on a work group to help with this form, follow experts like Tom and Mike on what this should look like. Tom, I'll kick it over to you. Perspective on this claims data, since you've been through many a data call.
Yeah, I actually like this, how they're separating the individual buckets, so to speak, of the claims that we deal with financially. And they're starting to track information that I guess previously was not tracked, which was surprising to me when Senate Bill 76 started, but I think this is a good measure to at least collect the data so we can establish what are the drivers of property insurance premiums in the state of Florida. I know there was a lot of debate about that in the Senate and the House. And I think ultimately this particular bill is a step in the right direction to track a lot of the stuff through the insurance companies. And I think there are other portions of the bill which will make it easier for the carriers to do so and submit this information. And I'm sure we'll talk about those sections a little bit later as it respects, fees, attorneys' fees, and things of that nature.
And Mike, I know you and I've, thank you for that, Tom. And Mike, I know you and I've talked about how, because this, of course, on line 217, it talks about the amount paid for claimants' attorney's fees. And claimant attorneys, those in the trial bar have expressed concern that they don't want, that's a tough nut to crack, but also we as defense lawyers have to, I'm not a lawyer, but have to divulge these fees. Think about this from a framework, Mike, and I'll get your perspective. A form is a rule in state government parlance. There will be a formal form rule hearing about the adoption of this form at some point. Where do you think, how as a company who has to comply with this claims data requirement, how will they get the claimant attorney fees? Any perspective about that? Do you think they'll be objections to that? What are your thoughts, Mike? Because we may have many of those claimant attorneys listening in, and they may want to know what our thoughts are as well.
So it's kind of interesting you bring that up, because right off the bat, when I first saw this, I thought about a couple of things. I think the first one is it's a lot of work, right? And that's the obvious one. This is something that is going to be a little bit of a burden on the carriers, and you know, the idea behind it obviously is to make sure that there is a way to track exactly what is going on within the market so that any further changes can be made that are needed. The attorney's fees part is a little bit interesting because you kind of juxtapose that against the idea that there may be confidential settlements that are reached, confidentiality agreements, and what is the interplay between a confidentiality agreement where somebody maybe doesn't want another party to know, possibly even the carrier itself, to know what a claim was settled for on an attorney's fee basis or an indemnity basis or the split. The other side of that too is that there's no requirement for a plaintiff or a claimant to negotiate their fees separately, or the plaintiff's attorney. And so you'll have, you know, many attorneys are more than happy to say, look, I want this much for my attorney's fees and costs, and I want this much for the indemnity. And if you're willing to settle it for that much, we'll settle the claim. But what happens when you have certain carriers who say the opposite, and what they say, or certain plaintiffs who say the opposite, and they say, we just want to settle it as a lump sum and we'll figure out what the attorney's fees are and we'll work that out with our client. And how do you get them to force that information? I don't know if you necessarily can. So there may be some hurdles to getting all of this information together in addition to the burden of actually having to put it together. But it seems like, again, the sentiment's in the right place. It creates a situation where it's not all just anecdotal stories as to what's going on, but there is actually possibly going to be some hard data that we can really follow and see what's happening with the claims, who the contractors are who are involved, what are the attorney's fees versus indemnity being paid out, who's being paid that money, and it'll allow the legislature and the governor and the state to kind of slowly maybe tweak this to maybe even make it more useful and protective of consumers.
Well said, Mike. I've had insurance industry executives celebrate this particular section. I've had those that have put their head in their hands and said, one more data call. I'll let each of our listening audience be the judge of whether it's which side of the fence they're on. Let's move on down to line 229 and going forward, Tom. Line 229 through line 238 is additional legislation where the Office of Insurance Regulation can further study, I'll just call it affiliates with insurance companies, within insurance company, holding company, within holding companies, you know, that house insurance companies and other affiliates, and the regulators, Office of Insurance Regulation, felt like they needed this. You see line 234, you know, any affiliates that are affiliated with the holding company, they've got the ability to do a deeper dive. Most insurance companies never object to giving anything to the regulators when things were asked for. We just thought this might be a little redundant, but for whatever reason, it gave the legislature great comfort to put this in. So we'll see what the Office of Insurance Regulation does about that. Let's move on from there and go on down to line 278. And on line 278, this is the public adjuster statute. And interestingly, the Florida Association of Public Insurance Adjusters championed this particular legislation. FAPIA is a willing and a good partner of many of ours in the insurance industry, because they try their best to police their own. And that organization actually was writing this legislation, pushing this legislation. Just like those of you in the legal profession, you don't like bad lawyers, giving all lawyers a bad name. The public adjusters, the same way. Many other professions, engineers, others, police their own. As you can see, this particular section, again, seems to target solicitations, such as on line 283, you can't advertise, solicit, offer to handle, or perform public adjuster services as provided in subsection 1. This particular section is tackling the unlicensed public adjusting prohibition. There have been sentiments in the industry where some have said, I'll just go ahead and get my public adjuster license and continue doing what I'm doing. You know, we'll see how that shakes out. Tom, you have worked with public adjusters on and off for as long as I've known you. In this particular section, do you think it strengthens it? Do you think it will kind of stem some of the unscrupulous bad public adjuster activity? What are your thoughts?
Well, I certainly hope so, number one. And then number two, I thought about that as I was reading the bill initially, whether or not, a bunch of roofers would go ahead and get their public adjuster's license. But I believe the prohibition against self-dealing through an affiliated entity still remains in effect, or maybe it's even stated in the bill, and I glossed over it, didn't recognize it. But there are prohibitions, within the existing Florida statute 626854, which prevent public adjusters from self-dealing or salvaging, property that they are under contract to with homeowners to present a claim on their behalf. So I'm hopeful that, again, enforcement, as Mike said earlier, is the key issue. And then secondly, making sure that, any loopholes in the bill or the revised language of the bill are quickly closed in the event that we have another storm in Florida and we don't have roofers out in the droves like we saw it in Hurricane Irma and afterwards, soliciting and getting around the anti-solicitation language via a loophole or two.
Go on down to line 300, if you would, Tom, and all the way down to line 329, and maybe you leave it, scroll up so that 300 is at the top of the screen. Yes. I want those in the audience to just really see some of the new language again, prohibitions, it's appearing that they're looking to try to clamp down on some of the solicitation on the roofing side. And even if you go on down to line 327, 329 in that area, you'll notice it talks about lines 328, 329, a $10,000, not to exceed $10,000 fine. So here's what I want the audience to think about it. And Mike, you can give us some perspective. For those of you that are reading this for the first time, you're thinking, wow, this is pretty sporty stuff. And you heard Tom talk about enforcement. We're only as good as the cases that we give to our regulator friends. They're overworked and underpaid. I respect them tremendously. And so if you see something particularly egregious, don't hesitate, just like any consumer would, to reach out to your regulators and say, I'm seeing this practice. I see the new law. How can I build this case for you to stop this bad practice? There's no harm in discussing before you submit something. What should it look like? We're hoping that the Department of Financial Services and some of those great soldiers there are going to be issuing some guidelines, something even more specific than this, about what a good case looks like, or what we should be doing as the general public, what consumers should be looking for if they want to complain or say that they've been aggrieved, and that they want to make a complaint about someone violating the statute. Mike, any thoughts about how we could help our regulator friends, be more engaged with enforcing, particularly this new, more weighty legislation about these practices?
Yeah, I would say two things. The first one is, I think it's all about vigilance. I think that what we see a lot of times, in some ways I may be as guilty of this as anyone. You come across instances where maybe somebody is adjusting claims who's not an adjuster, or is doing things in the context of an adjuster, and maybe there are other things going on in a particular claim that seem a little more, a little more meaty, I guess, for lack of a better phrase, and that's what you tend to focus on. But I think there's got to be a transfer of information to the correct people who can investigate this and address it, because we all know, we hear it every day. You hear insureds who are in depositions or in examinations under oath, and they say things like, well, I paid this particular contractor because they were going to handle the claim for me. They were going to do all of these things, and the reason I paid them more is because they handled the claim. So you want to make sure that that's limited to the public adjusters, because that's what their license is for. Whether that's better or not, that's for another day. I would also go back to what we talked about at the very beginning, and this isn't going to come up that often, but there have been instances where we've seen this. If somebody's not a licensed contractor and they're trying to do contracting work, not only are the penalties that are available here available, but there's also a statute 768.0425 which if you have a claim against an unlicensed contractor for negligence, malfeasance, or misfeasance, you're also entitled to treble damages for any compensatory damages you have against them, as well as attorney's fees and costs. Now, that's usually on behalf of the consumer, but just off the top of my head, and this is something that if anybody ever had any questions, they can contact Tom or myself or your own counsel, they could probably tell you this. But there are situations that come up where you may be able to avail yourself of those kinds of remedies as well, even potentially as a carrier, which is another maybe hook to kind of stop some of the things that are going on.
Very well put.
I just wanted to interject because there was a statement in the chat by one of our participants. So it was pointed out that lines 308 restrict public adjusters from inspecting the roof. That's not actually true. They're not allowed to offer a rebate, gift card, cash coupon, or any other thing of value in exchange for allowing a contractor to inspect the roof. It doesn't restrict PAs or roofers or contractors from getting on a roof, and I want to make sure that everybody is familiar with that portion of the bill and not misunderstanding it in any way. Obviously, a public adjuster should be able to get on a roof, should be able to evaluate the roof, and is duty bound by a statute to prepare an estimate for damages on behalf of the insured, particularly or specifically in response to a request for a sworn statement and proof of loss. I also mentioned self-dealing earlier. That's Florida Statute 6268795. Yes, I had to look that up, but I knew there was another statute restricting it. So for anyone interested in, being a roofer and a public adjuster, it seems like you can do one or the other, even though the language of the bill taken in isolation seems to, promote roofers that Mike and I deal with in the courts to simply go get their public adjuster's license and do everything in a one-stop shop. It doesn't work that way, and I don't think, I think all of those statutes will be enforced, hopefully, again, to the protection of consumers. And Mike said something very important that I don't want to gloss over, which is what we deal with every day in not only depositions, but also in the courts of the state of Florida when we're trying these cases, are the homeowners who are testifying and have absolutely no idea of what's going on. We have a lot of elderly citizens in the state of Florida, 2 of whom are my parents. They've never been on their roof. They will never go on their roof. So they trust in professionals who knock on the front door to evaluate damage in the event of a windstorm. And legitimate damage should be paid for by insurance carriers and repaired. Okay, manufactured or created damage should not. And we not only need enforcement through the state of Florida, but we also need the insurance industry and the public, and that includes the public adjusters and plaintiff attorneys, by the way, to, as Lisa said earlier, police the industry. You can't go up on a roof and see a crack, in my estimation, and say, oh, that was a result of Hurricane Irma. You get a brand new roof. It just doesn't work that way. Doesn't work that way in construction. Doesn't work that way in any other industry. And it shouldn't work that way with respect to property insurance claims in the state of Florida. And I'm sorry to get on my pulpit, but I need to say that.
Okay, I got you. Everybody said, can I get an amen? Go ahead, Mike.
Yeah, one quick thing. I don't want to belabor this point, but and this might just be a problem that we're saddled with. There are instances where you have a particular contractor, whether it be a roofing contractor, general contractor, who maybe goes out and gets a public adjuster's license, like Lisa mentioned, or maybe what they do is they have an affiliate go get a public adjuster's license. And in those circumstances, there can be even further damage on a claim than what we even normally think of, because what you then have is you may have a circumstance where the 20% or 10% or 15%, whatever percent it is, public adjuster's fee is also getting kicked back out of the original indemnity payment back to the same group of actors. It's like another revenue stream. So again, I think that the sentiment and the motivation behind these provisions is very, very good, and it's well placed, but it's almost whack-a-mole. You create these, you create additional problems. And so it's just something that we kind of have to think about.
You're on mute, Lisa.
Oh, you're on mute.
I want to move on to line 1010. If you can scroll down to that line, and while you're doing that, I want to let the audience know that there are probably 6, 8, 10 pages in the bill that deal with citizens property insurance. It allows citizens to raise their glide path that's currently capped at 10% by 1% a year. It requires that citizens, you're going down to line 1010, Tom. It requires that citizens include in their rate filings the fact that they bought reinsurance, even if they didn't, because there is an attempt to get citizens rates up. Those of you that are insurance scholars understand why that is. For those of you that are consumers that might be watching this, that may seem painful to you, but there's a method to our madness to have citizens rates up as high as they possibly can be. I'm happy to talk with any of you about the citizens changes. Barry Gilway, who's the leader of Citizens, one of my personal favorite heroes, at the podium every opportunity that he had to try to make change in the market. A seasoned professional that if you've never met, you should have the opportunity to do so. So I will certainly answer any questions about Citizens, and if I don't know it, I'll ask Barry. Let's go on to page 1010, line 1010. There's one sentence here that I'm going to have Tom and Mike comment on. I'll let you read it on your own. It's in 2 places in the bill. It's in the surplus line section and then here in the admitted market section. And it talks about how attorney's fees are going to be paid. And Tom, I'll let you comment on it, read it out loud, whatever you'd like to do, because there's a lot of discussion about this one sentence. Tom, I'll turn it over to you.
You're talking about the sentence that I've highlighted?
Yes, sir.
Okay. Yeah, for practitioners in the courts like Mike and I, this is kind of where the bill starts to get very interesting for us. In particular, beginning with this line that Lisa referenced, in a suit arising under a residential or commercial property insurance policy not brought by an assignee or an AOB, the amount of reasonable attorney fees shall be awarded only as provided in the following statutes: 57105, which is the Florida statute related to sanctions and civil litigation, or section 627-70152, which this bill creates. So if you go to other portions of the bill or that maybe we glossed over, most of what Mike and I deal with are claims under 627-428, and 428 now points you to 627-70152 as of the effective date of this particular legislation. So
that
yeah.
70152, Tom, is on line 1075, and we'll get to that.
Yes.
So let's just kind of put a pin, as the kids say, up there at line 1010, knowing that there's just now these 2 statutes, and we'll weave that into our conversation. Just for those in the audience, recognize attorney's fees are paid with respect to 57105 and the new statute that we're going to talk about that's referenced in line 1013. Let's quickly go down to line 1016, which is the section of the law that changes the limitations on when we can file claims, and particularly for those of you that want to see how it was reduced from 3 to 2 years, that particular section of the law, where is that? Wait just 1 moment, please. Yes, that's on line 1035, from 3 years to 2 years. And then there's other provisions with respect to supplemental claims, what a reopen claim is. Mike, you want to comment about this particular section? And I know this is going to be debated heavily in the courts. You know, when did it happen? When was it reopened? But just your perspective.
Yeah, I mean, I think it's good. I think, you know, right off the bat, that's kind of the simple answer. I think that what we had before, I forget the exact statute number, but there was a statute regarding supplemental and reopen claims. Obviously, with the 3-year repose issue that we've all been kind of accustomed to deal with when September 10th and September 11th came by last year. But also there was a section of the statute that talked about reopen and supplemental. This is nice because it kind of differentiates between the two, which I think we've all kind of in our mind understood what the difference between the two are, but it was never expressly stated like it is here. And the difference in time period is makes sense, right? If I come and I make a claim for damage to some portion of my building or home, and I get a payment or denied or whatever the case may be, and then I come back and I'm asking for the same thing or additional money for the exact same place, that's limited to 2 years. And that makes sense, right? If you're going to talk about the same thing, you should probably know within 2 years whether or not you need more money or you don't need more money. Whereas the supplemental definition is obviously a little bit different. You're talking about either new or additional damage or costs for, basically replacement cost, value cost, additional costs incurred in making the repairs that maybe you originally claimed, and that gives you 3 years. And so the difference between a reopen and supplemental and the differentiation there, I think, is important. I think it's good. I don't know how often it will necessarily come up, but in those instances that it does, it's nice to have a differentiation between those two kind of nomenclatures, because we've always kind of understood it, but nobody's ever said it. And so now we at least have it in writing.
I love it. All right. In the interest of time, I want to move on down.
Actually, I'm not going to let you, Lisa, because I'm going to say one thing real quick. This replaces the same statute, and the statutory language was previously restricted to win-loss claims only. Now it's to any peril. So any claim is going to have this 2-year reporting or 3-year reporting requirement. So what happens on the industry side? You got to get this into your policies. You got to get it into your policies quickly. The statute's taking effect, I believe, July 1st of this year. And one theme that I don't want to belabor as we go through this section of the bill is that there are going to be a lot of conflicting policy provisions in existing policies that have not yet been renewed. So getting the new legislative language, which has all this procedural stuff about requiring notice and restricting attorney's fees and all of that stuff, carriers are going to have to figure out quickly how to get a lot of this pertinent language into their policies. Because if they don't, the policy is going to control, okay? Your contract controls in the event of a conflict with a statute, particularly on substantive issues. So if you give someone by contract 3 years to report win-loss claims only, okay, and you don't put that 2-year reporting requirement into your statute, or into your contract, the contract will control.
Very good. Thank you for that point. All claims. All right, let's go back to the bill, and I'd like to get to line 1075, which is the new section of the law that we referenced where it talked about attorney's fees being paid. And the title of this new law from lines 1075 all the way down, it literally goes all the way through to line 1220. Tom, I'll let you and Mike, we've batted this section around. This is really the guts of the law. I'd like you to talk to your audience about what you see with this new section. Does it help? Does it hurt? Will it be interpreted? I'm glad I'm not a lawyer. Yeah. Tom, we'll start with you.
This is a very challenging section of the bill, and I do not have a crystal ball or the power of foresight into the future. So what I can tell you is that a lot of these new provisions, both above line 1075 and below line 1075, are likely going to lead to a lot of litigation in the short term. I don't know how it's going to play out over the course of the long term, but one thing that I think we all know as a result of litigating these types of claims for a long period of time is that you typically do not find out about the opposition's or the plaintiff's right, entitlement, and amount of attorney's fees except under 2 specific instances. Number one, the carrier loses the case at trial, okay? And very few of these cases are actually tried, although I think this new litigation is going to potentially lead to carriers being a little more, or a little less, excuse me, risk averse in trying some cases, particularly where they've extended coverage. And we'll talk about the notice provisions related to this bill later. But then also, if you confess judgment, and you confess judgment under the terms of, after litigation has been filed, and you have the court evaluate the amount of attorney's fees. One thing that I was surprised about, and again, if I've overlooked it, please point me out and hold me accountable, but I did not see anywhere in the bill as I was reading through it that sort of dealt with the federal standard for the contingency risk multiplier. And that was something that we were hopeful would be addressed by the legislature, and maybe it will be in the future, but it hasn't been in this particular bill. And that's really what drives litigation on the property insurance side. The risk that a court, particularly after the Joyce decision and those that followed, will be handing out contingency risk multipliers left and right. This new language that requires notice and requires an estimate and requires carriers to respond within 10 days, in my estimation, is likely going to embolden plaintiff attorneys and policyholder representatives to try their cases where the carrier sticks to their guns and supports their denial of coverage, or doesn't try to get out of the suit. If I were a plaintiff attorney, and there are much better plaintiff's attorneys than me, I'm a defense attorney, but in all fairness to my colleagues on the opposite side of the aisle, I would be arguing, hey, we gave them the chance. We gave them a chance early on. We gave them an estimate. We told them that there were flaws in their coverage evaluation. They stuck to their guns, and here we are. The jury just awarded over 50%. Now we get our fees. We're entitled to a 2.0 multiplier or higher, and we think we're worth $750 an hour, whatever. So I do think this is going to be interesting, and the real, I'll shut up now, but the real overarching theme is that everything in this bill, as it relates to attorney's fees, and again, in my estimation, is a work in progress. It's going to have to be litigated through the courts. And as we were talking about the other language, somebody within the audience pointed out, well, what about the PFS statute? Yes, there's a PFS statute. And yes, Mike and I and our colleagues on the defense side file a lot of them. There are going to be arguments that the PFS statute is no longer available as a result of that language that I previously highlighted, because it says attorney's fees are only awarded under these two statutes, and they don't specify the PFS statute. So those arguments will be made. I don't think there's anything in the legislature that struck or negated the PFS statute, but I know there will be legal arguments, and where there are legal arguments, there are receptive judges. So be prepared.
Well said, Tom. Let's, before I let Mike speak, if you'll scroll up a little bit, because this particular section has, as I said, it's the meat of the bill. So if you can actually scroll up, yeah, I meant not up, down, like get to line 1105 and line 1138. So 1105 talks about the notice. 1138 talks about the insurance company duties. The 10-day notice, that's there in 1105. You see there on line 1107, it talks about a claimant must provide the department with written notice of intent to initiate litigation on a form prescribed by the Department of Financial Services. There are those who are talking to the Department of Financial Services asking about what that form will look like, because this bill's due July 1. This bill takes effect July 1. So what will that form look like? Consumers are going to need to be aware of it. Do the plaintiff lawyers complete it? It says very specifically, you know, the claimant must do so-and-so. There was debate on the Senate and House floor. How would a policyholder know how to do this? And the sponsors of the bill said it's going to be a simple form. So Mike, you want to comment about this particular notice provision? And then of course, underneath that, in the interest of time, not only the notice provision, but their on line 1138 where the insurance company's responsibilities are in this new section. Mike?
Yeah, I'm going to go quickly. I have a few things to say here. I think the first one, to go back to the PFS issue, I think the issue with the PFS is, and I'm not, I don't know if we have our friends on the policyholder side listening in. We probably do. I'm certainly going to maybe keep some of this close to the vest. But, a PFS pursuant to the rule, pursuant to the statute, is allowed to be served in any civil action for damages. The new fee statute here says that the only, in a suit arising under a residential or commercial property insurance policy, the amount of attorney's fees shall be awarded only as provided in these sections. There's obviously a little bit of a problem there with respect to whether or not those two are consistent. You go to issues of statutory construction, you might be able to get to an answer. I certainly am not going to say what I think the answer is, but I think you could probably argue it a number of different ways. A couple of things about the pre-suit notice requirement that jumped out at me. I thought the first one that I find interesting, which honestly, I find it a little bit bothersome, is that there's an inclusion of pre-suit attorney's fees in the pre-suit notice. Well, under the prior fee statute, you're entitled to fees based on a lawsuit or litigation filed. So why would anybody be demanding pre-suit attorney's fees in a pre-suit notice requirement? And why would a carrier be on the hook to pay those? And I think there's going to be litigation as to that, because I think that needs to be hashed out. There's no requirement that you pay pre-suit attorney's fees. There's some case law in federal courts that maybe it's a little bit different, or state courts, maybe you can argue it one way or another. But in general, by and large, you should not be having to pay those. So I thought that was a little bit odd that would be included in the pre-suit notice requirement. I also think that with respect to the language as to the attorney's fees, and again, if I were somebody who was going to be litigating these issues, there are issues with the language and things in the language that I think you could probably twist and turn that could be problematic for both sides. So I think the language could have probably been a little bit cleaner, but obviously hindsight's 2020, and who am I to judge what was being put together? But when you look at the final version, there are some issues that I think you could raise. I think the big thing about the notice requirement, even if, let's say, you did not have a PFS going forward, which I know bothers a lot of people if that ultimately ends up being the case, and I'm not necessarily saying that is the case, but let's say it is for purposes of argument, I think the pre-suit notice requirement is still a benefit. In talking to clients about this, one of the things that was brought up, which I think is really, really good, is that it gives the carriers 10 days to go back and look to see if maybe there was a mistake made. Maybe they should go pay something. Maybe they do owe more money. They're not just going to get slapped with a lawsuit out of nowhere. They have an opportunity to go back and look. From my perspective, when you look at the attorney's fees section and how the amount of attorney's fees may be tied to what the pre-suit settlement demand or offer is, one of the things that jumped out at me is what happens a lot, and I know a lot of people on our side of the V see this. You'll get somebody who will come in and they'll have a particular claim, and let's say they demand $100,000. You'll have another person who will have the identical type of claim, and they'll demand $600,000. And what that does is it strikes kind of fear into the heart of a carrier, and so it'll move the needle. And so the person who demands $600,000 might end up benefiting more than the one who demands $100,000 for the same exact claim, just because of the raw numbers and just by the force of demanding that much money. Well, now if your ultimate recovery of attorney's fees is tied to the percentage of what you demanded, it will then necessarily have to drive demands down. You would be, if you are assuming the statute plays out the way I think it was intended, for lack of a better phrase, you'd be an idiot to over-demand, because if you over-demanded, then you ultimately might be prejudicing your ability to recover your fees later. So what may be a consequence of all of this is more reasonable demands, pre-suit investigation abilities that will allow you to then take a reasonable demand and then ultimately determine whether or not you want to pay it. And then on the denied claims, you have 14 days to go re-inspect, which I think is also very, very important, because especially in the context of CAT claims, we all know that in catastrophe claims, there are claims going on all over the place. And people are out there and they're stretched to the limits on inspecting certain claims, and everybody does the best that they possibly can. But there may be instances where you say, you know what, I want to go back and look at that one again. And you have the 14 days to do that on a denied claim. And if ultimately you decide, hey, you know what, we missed something and we should pay it, you have that opportunity to do so, to prevent yourself from being sued. So I think the notice requirements are really, really beneficial if they play out the way they should. And I think the big one is it gives you the opportunity to have a second look. And it also, I think, will lower demands, and it will not incentivize over demanding by policyholders and their representatives going forward.
And to go along with what Mike just said real quick, it also, in responding as you, by the insurance carrier, as you look through the bill, the bill also kind of incentivizes insurers maybe to offer more during pre-suit negotiations than they would, post-suit, particularly if you've made a fair offer and it was rejected and you're now in suit paying your defense costs anyway. So the bill is, I think, as Mike indicated, well intended. I know that a lot of my carriers who we represent, and I'm sure other carriers as well, would prefer to have 10 days notice as to whether or not they were going to get sued. 20 would be nicer, 30 would be great, but we'll take 10 rather than just saying, hey, you haven't made a decision in 90 days, but and we haven't complied with the policy terms and conditions, but we're going to sue you anyway and let the judge hash it out. At least that's not going to happen any longer, and I think that's a very good aspect of this bill.
Thank you for that, gentlemen, and I want the audience to really deep dive, going all the way through as Tom is, down to line 1138. You see where it talks about the insurance company duties. You're going to need to read this on your own. 1174 talks about dismissal of a suit, and 1180 is the admissibility of notice and response. In the interest of time, I think that I love to say this and not a lawyer, we reserve the right to call Tom and Mike and have a brainstorming discussion about this particular section of the bill. I do want you gentlemen, though, to talk about how the attorney's fees will be. Look at line 1193. If you look at line 1193 and go all the way through 1220, Tom, comment on that. Mike, comment on that. Then we're going to close this out in the next 5 to 7 minutes. Tom?
Sure. Let me, instead of sharing the bill, or instead of sharing this particular section of the bill, let me share with you attorney math, which is going to be embarrassing for me, but hopefully it summarizes this a little bit.
Okay.
With respect to, honestly, for those of you who are attorneys, you can empathize with me or sympathize with me, but doing math makes my head hurt. And Mike and I don't do a lot of math in our practice, and now we're essentially required to do math when we're advising our insurers how to respond to a certain thing. So what I did is kind of just put together a summary that hopefully everybody can see right now, and it starts here and it concludes all the way down here, and I'll highlight it. But this is basically a summary on the section of the bill that Lisa was just describing, how to calculate fees. So I think the only way to do this is to provide an example, because essentially a pre-suit demand will be submitted, a resolution of the claim will not be reached, litigation will ensue, the case now goes all the way to trial. What happens at trial? That's really where this legislation takes impact. And again, I think the point of the legislation was to avoid that circumstance altogether. So let's not overlook the fact that, many property insurance claims do not go all the way through to trial, but those that do will be facing a new allocation of fees. So if the claimant here, starting with, for example, let's say the claimant made a pre-suit indemnity demand of $50,000, not including attorney's fees and costs, and the carrier made an offer of 10. There's a disputed amount, in quotation, of $40,000. Okay, so now we go to trial and the jury awards $35,000. Okay, I'm sorry, difference between the amount obtained and the pre-suit settlement offer is, that should say, 40,000, I think, which is more than 50% of the disputed amount. So the carrier will still pay the entire plaintiff's attorney's fees. And again, I am no mathematician, so forgive me if that calculation is incorrect. But in another scenario highlighted here, now the award is $20,000. So the difference between the amount obtained and the pre-suit settlement offer is $10,000, which is 25% of the disputed amount. So here the carrier will pay plaintiffs reasonable attorney's fees and costs equal to 25% the total amount of fees. So if $100,000 is awarded by the judge after trial, the attorney or the insurance company would be responsible for $25,000 of that. And then lastly, if the insurance carrier wins, then there's no fees. That would be paid by the insurance carrier. And a win is not necessarily a zero verdict anymore, which takes us back to the pre-suit notice requirement. So attorneys are now going to have to do some math in advising their clients. Not necessarily a good thing, but we'll all figure it out. More importantly, the policyholder representatives on the other side are, like Mike said earlier, probably better than I can, really going to have to evaluate their claim, and not in the context of, you know, demanding a king's ransom, but demanding an amount closer to what the actual repair costs of the individual claim is likely going to be. Again, I believe the carrier is incentivized to offer more pre-suit than post-suit, particularly on covered losses. And then, of course, there's the denied claims, which, you know, who knows what happens on those, how much you offer, how to create this delta between the amount demanded and the amount offered by the insurance carrier. All a work in progress, all will be litigated. And for those practitioners in the audience on either side of the aisle, particularly if there are any mediators or arbitrators attending, get ready to start, evaluating and making your arguments as to, well, if I do this, then you're going to have to do this. Coupled with that, we talked about the PFS and how that ordinarily works into the fold. So these are just added restrictions or requirements, excuse me, that we're going to have to deal with in litigation. I think this portion of the bill is, again, well intended. I think it is actually designed not to get to the point where a trial is imminent or necessary as a result of this stuff. And then, of course, the bigger numbers you're dealing with are going to get more complex in terms of evaluating pre-suit demands. So for those commercial property insurance carriers who are going to be dealing with pre-suit settlement demands, might be a little more difficult the higher you go.
Before you go, Mike, I have a question from the audience. What happens if the pre-trial, the demand is increased beyond the original pre-suit demand? What are your thoughts about that?
I'm going to answer that in a second. I got another really interesting question that I thought, that I hadn't actually thought of, that I think is something to keep in mind. Somebody had sent me an email and said, what happens if the pre-suit notice of intent to litigate is the first notice of the claim? What happens? How do you stop that? And I think that it's an interesting point, and I think it's probably something we've all glossed over, but it certainly could happen. You get a letter in the mail from an attorney that says, I'm going to sue you in 10 days, figure it out. Here's my estimate. And how do you adjust that entire claim within the 10 days? And how does that work within, 627, 70131 and the 90-day requirement? I think from my perspective, without thinking about it more, I would probably say that you end up in a situation where can they prove that you breached the contract if you didn't adjust it within 10 days, right? Somebody gives you 10 days to adjust the claim and then sues you. I think my response would be, if I didn't pay you, I didn't breach the claim. You gave me 10 days. I couldn't have breached the policy. You didn't give me an opportunity to adjust. You didn't give me an opportunity to decide whether I was going to pay or not. So how can you say that I breached? But it's a really interesting point. So your question, or the question was, what happens if the post-suit demand is higher than the pre-suit demand?
Uh-huh.
Well, I think that you're measuring, the measuring stick is whatever the pre-suit demand is, and I wouldn't be surprised if you had people set it up that way. I mean, putting, you know, I hate to say this, but putting my plaintiff's attorney hat on, maybe, well, I'm not even going to say what I would do, but
Yeah,
what
but
I will
so
say
before
is,
you go, you can't file pre-suit demand until the 90 days is over, right?
I don't know if you can or you can't. I mean, I don't know if you could say, here's my notice of intent to litigate the day you file the claim. I mean, when you look at the notice requirements, you have to provide first notice of loss and all of that information, but I guess you could say my first notice of loss is today.
We will be discussing this more and more with others that are smarter than I am, because we're running up on our 11 o'clock. So bring us home. We've covered this bill beautifully. A couple more provisions. We can talk about it another time. Go ahead, Mike.
I was just going to say, somebody in the audience made a point, and that may be, they may be right in getting the question. I may not have seen that. There may be something in there that does require you to have a coverage determination before you give the notice of intent to litigate. And if that's the case, then they're 100% correct on that. As far as the post-suit demand being higher, I guess my point would be, you're going to see that a lot. I think you're going to see a very reasonable pre-suit demand, and if you don't pay it, then the post-suit demand will probably be much, much higher, because you're not going to be dealing with the same attorney fee shifting issues that you would have on the front end. So I would expect that. I would expect to probably see a reasonable demand up front, and then probably a much less reasonable demand the second the suit is filed.
I see questions, Tom. Thank you for that, Mike. You want to throw these out of the audience and see what we
Sure. I have some. I'm not sure if you guys can see it or not, or I'm not sure whether or not people can see the questions that are coming in, but there are a lot of them. There are a lot of good ones. I'm going to go with the easiest and then the to the more complex. And again, we actually have this till noon. I don't anticipate to be here till noon, but nobody's going to get kicked out if anyone's still awake and still listening to Lisa, Mike, and I. You're not going to get kicked out. So you can keep the questions coming if you're interested. But let me just start by saying, first of all, just to reiterate, and I put this in the chat, the bill takes effect July 1, 2021. So 16 days from today, essentially. Somebody asked about the time limits associated with the statute of limitations for property insurance claims being tolled. Look, I mean, if you read through the statutory language, you can see that in the circumstance where a consumer is running up against the statute of limitations in order to file the claim, the legislature is going to give them the benefit of the doubt and extending the claim by 10, or extending, excuse me, the statute of limitations, or tolling it by 10, 14 days, whatever the case may be. Somebody also pointed out that the statute says you can't send a pre-suit demand if the carrier has not made a coverage determination. That's true, it does not say that. And there are other statutes, particularly in the example that Mike was giving earlier, with respect to the 90-day requirement. There is still a requirement that, there is still a requirement that we adjust on the insurance side and investigate and make a coverage determination within 90 days, unless circumstances beyond the insurance carrier's power or control delay the 90 days, so to speak. That statute, and I can't remember off the top of my head which one it is, but it's really important that that does not provide a civil cause of action or a right of action. I think the issue is that I've seen a few carriers put that in their policy and make corporate representatives very uncomfortable with respect to the 90-day language. Well, isn't it true that you didn't do this, and isn't it true that you didn't do that? So we're still going to have to deal with that stuff. Another one, with a good one that I saw with respect to roofers. Yeah, so roofers who follow hailstorms, so to speak, and might solicit business as a result of hail damaging roofs. And yes, there is coverage under most insurance policies for roofs. As I read through the roofing portion and the roofing restrictions or construction company restrictions associated with this particular statute, I think if they follow the notice, or they follow the requirements of what they can put in their ads and things of that nature, I think the roofers are going to be okay. There is certainly some confusion related to those requirements, and whether or not good roofers are going to be restricted from handling or soliciting insurance work. And I would suggest that if the roofers are following the guidelines set forth in the statute and they're doing the right thing, they're not adjusting the claim, they're not adjusting the loss through others, they're not offering benefits, rebates, gift cards, or other things of value, I think they're going to be okay.
And Tom, just to comment on that, remember, you get in trouble when someone submits something to a regulator. If, you know, so it's not like there are DBPR field people canvassing neighborhoods looking for, I mean, they just don't have the staff to do that. So you talk about a good roofer versus a bad roofer. I don't want to get the definition of that. I think you're right. Good roofers understand that knocking on doors is a part of a marketing campaign, but you know, if they're very strict, they have the guidelines, they can take the statute with them and show it to the consumer and say, here are my guidelines, here's what I'm able to do. I want to give you a copy of the statute under complete transparency. And please note, I'm not violating these statutes. That's just a fail-safe way of staying on the right side of the law. Back to you, Tom.
Sure. And then we get into some of the more complex questions that were submitted. Thank you for all the questions. If I missed any, we'll try to address them after the presentation. But one thing that was not addressed in the statute, obviously, is your partial coverage, partial denial. For example, you know, we have these section 2 of the exclusion of most homeowners policies. The peril insured against may provide coverage for ensuing loss. So with respect to a roof claim, for example, you have, you know, poor flashing, some sort of mechanical defect that's allowing water into the home. The interior damage may be covered and paid for by the carrier, but the roof obviously denied. I think that's going to be interpreted as a covered loss because a payment was made. I would suspect that you would get a demand for a roof replacement and all of the accoutrements, as well as a demand for more than what you paid as an insurance carrier on the interior. All of that is conjecture and suspicion on my part, but I'm confident enough and been doing this long enough to say what you're likely to see. I do think if you make a payment, it's going to be interpreted as a covered loss as opposed to a denial. And I think the pre-suit settlement or notice demand is going to hash that out in the long term because there was a payment. But it is not accounted for in the statute. And I think, yeah, that's a very astute thing to point out. With respect to...
And one more thought, Tom.
Sure.
I have a legislator that's willing to take this bill and fix any glitches for a glitch bill in 2022 session, January 2022. So if the audience wants to send it to you and you and Mike massage the idea to amend the statute, get it to me and I'll get it to this legislator who's already volunteered to fix what he sees are problems. Back to you.
Another question, do we know if the state will be receiving the 10-day notice of intent to litigate at their website, or will they be creating a new website specifically for the notices of intent to litigate? That's Lisa's department. I'm not sure she knows the answer to that question.
We've been talking with Deputy CFO Julie Jones. Several people have. I know Julie. You're certainly welcome to reach out to her. She's very approachable, and they're just trying to put their hands and arms and feet around implementing this bill. You know, whether they set up a separate system and you can view those transparently, no one knows. But would you, at least those of you that are curious, please keep us in the loop that you're still inquiring about it, because it helps us communicate to regulators that it's not just me or an insurance company. This really affects practitioners in the field. And I know that the DFS is doing everything they can to implement as fast as possible. And in fact, Senate Bill 1598, an additional section of the law dealing with solicitation, was signed today. It kind of broadens what 76 did, and we may do another webinar about that. So DFS is on top of it, doing what they can. Certainly doesn't help for us to contribute and manage upward. Back to you.
Probably will end up being something, my guess would be, because it does work very, very well, is similar to the CRN portal, where you can file something with the department and ultimately everybody is notified that way. And it's a very efficient practice, but I guess nobody really knows. But in order for the notice requirement to work, it's going to have to be efficient. People are going to have to be put on notice. Otherwise, you're going to be litigating this all day long. So it seems like there's really not a ton of time to figure it out, but somebody's going to probably have to figure that out pretty quickly. I want to go back to the question that somebody raised before, because they were 100% right. I went back and looked, and right in there in the statutory section, the notice of intent cannot be served until there's a claim determination. So I think the issue then that was raised by the question that was posed to me might be something that may come up more in the context of a reopened claim or a supplemental claim. You're probably not going to get it on the initial claim, because you're going to have that initial coverage determination before a notice of intent to litigate can be made, which is good. That's a good thing. At least it's a good thing for the carrier. I'm not necessarily sure it's a good thing for the policyholder, but it's a good thing for the carriers.
Yeah, a couple more real quick before I get to one very specific question. Do you think that the option to elect alternative dispute resolutions or appraisal is meant to go through the DFS process as to mediation, or will it matter if you elect to go private with mediation? If you are going through, on either side of the aisle, if you're going through the alternative dispute resolution process to resolve a claim, you're going to receive the benefit of every doubt, in my estimation. Courts force us there all the time once we're in litigation, particularly if anyone has ever been in small claims court or county court, the judges at the very first appearance will send you out into another room and say, go figure this out, resolve this, get it out of my courtroom. So participating in any kind of appraisal or alternative dispute resolution is usually going to happen by agreement between the parties. So even if you get a DFS mediation request, and this has happened to me in the past, maybe to some other people, and you want to go private in terms of mediation, I think you're going to be able to do that. And I think the carriers should be willing to pay for that service, as they are required to pay for DFS mediation. A lot of times with private arbitrators and mediators, particularly those who deal with first-party property insurance claims regularly, they're going to be of more value to you, and that means everybody, than a DFS mediator who is appointed but has no familiarity with a first-party property insurance claim. So I don't think you're going to get any pushback on that. And finally, we were called out as panelists for skipping over the insurer duties section. So I just want to share that real quick. It's highlighted, and Mike and I, or I'm sorry, I'll maybe ask or throw it over to Mike to comment. But it starts at line 1138 of the bill. It's highlighted here, and it goes all the way down to the 1173. So we do have, some concerns here. I think one of the things, when Lisa was talking about a glitch bill, and it's not in this section, forgive me, but for a denied claim where you're sending the notice of intent to litigate, on line 1122, it says, provide an estimate of the damages if known. I get rid of that if known. And I would require people to submit an estimate of damages. Couple reasons for that. Number one, public adjusters, again, are statutorily and duty bound as fiduciaries to their policyholder to create an estimate, particularly in response to a sworn statement of proof of loss. And also contractors are at the ready to perform work in the state of Florida. So getting an estimate for a policyholder, particularly their representatives, is not going to be hard. But if we're dealing with glitches in the bill, I could foresee a demand coming in and saying, hey, we think it's $200,000, but we're not really sure. We don't really know. Obviously, not everybody's going to take advantage of that, but there will be some. So I was a little concerned about language and wanted to point it out. But starting with the insurer duties, Mike, you can see an insurer must have a procedure for the prompt investigation, review, and evaluation of the notices of intent to litigate or disputes, pre-suit disputes that will be submitted under this new statute. So in looking it over, do you foresee any issues, anything carriers need to be aware of in responding to these, having procedures in place and then responding to these particular disputed amounts?
I mean, a couple of things jump out at me here. And to respond, to the question that was raised, I think the first thing is it's a little bit more work again for the carriers. You're going to have to come up with some kind of a policy or procedure, it sounds like, for how to deal with these. I don't necessarily think that that's something that will be too difficult. You are going to have a truncated inspection period or investigation period. Obviously, on the denied claims, you'll have 14 days. On the non-denied claims, you'll have 10. So there's going to have to be some kind of procedure in place for how to deal with these, and you're going to get a lot of them. The part of it that I find problematic that I don't like is the obligation to make an offer if the notice alleges an act or omission other than a denial. Honestly, I think that that's going to probably be challenged. I think that there are problems there. If I pay $10,000 on a claim, and then somebody comes back with a reopen or a supplemental claim and asks for more money, or gives me a notice of intent to litigate after I paid the $10,000, I don't know why I would be required to make a offer. I may say the $10,000 was sufficient. Why am I going to pay another dollar? And the statute seems to suggest that it's mandatory that an offer be made unless you're sticking by a denial. So if you didn't make a denial, then according to this, you'd either have to make an offer or submit the claim to appraisal or non-binding arbitration or ADR. Obviously, dealing with appraisal and things of that nature, we all know some of the pitfalls with that, so that may not be desirable. And going to alternative dispute resolution is expensive. What I would probably suggest doing under those circumstances, and it's not to be, not to be kind of flippant about it, but if you pay $10,000 and you think $10,000 is sufficient and you get a notice of intent to litigate and you don't think you owe any more dollars, offer a dollar. Here's my pre-suit settlement offer. It's $1. Because what I really want to offer you is $0, but the statute's suggesting that I have to pay more than $0. But I'm not even necessarily sure that stands, because I'm not necessarily sure that a statute can require a carrier to offer more than what it ultimately determines in its adjustment in the claim. But it's a little bit of a problematic language that maybe needs to be addressed in some later version.
Yeah, and I just to dovetail on what Mike said, I was curious about how the interplay between ACV and RCV would work under statute 627-7011. The carrier pays ACV and you get an RCV demand. Sure, you can apply depreciation to the scope that was submitted to you along with the estimate, the disputed estimate, and apply depreciation to that amount and offer to make a payment. But I'm curious as to how the requirement that the insured policyholder is required to perform work and submit invoices as expenses are incurred will kind of work through this whole statutory language. It's really unclear. It doesn't deal with ACV, RCV in any way. And I think all of us know on the insurance carrier side and probably on the other side as well, that our contractual and statutory obligations on the insurance side are typically to pay ACV. I'm not sure that there's anything that stops a demand from coming in that's full replacement cost value. Again, I don't want to reiterate, but I do think this language incentivizes insurance carriers to offer more than $1, and it probably incentivizes them to offer something closer to what is being demanded prior to dealing with a lawsuit, paying Mike and I to defend it. There are still going to be obviously litigated claims, and there's still obviously going to be disputes that go through the court system in order to resolve, be it by trial, mediation, alternative dispute resolution, arbitration, whatever. But one of the things that, you know, if we're talking about specific duties, if you get a notice of demand to litigate and you're responding on a denied claim, the statute affords the insurance carrier an additional 14 days after the response deadline to reinspect the property. So even if, as Mike pointed out astutely earlier, you know, you have your 10 days, you now have 14 days. If you're, for example, submitted along with the notice of intent to litigate, you're submitted a plumbing report, a roofer's report, an engineer's report that suggests you missed something, take advantage of the 14 days. Go back out, reinspect the property, and make sure there is support for any response you're going to submit as an insurance carrier. I think that's a very important aspect of this particular bill, and I think that it's one that insurance carriers should take advantage of. I wouldn't be, again, too worried about the, you know, tolling of time limits afforded by 9511. You're talking about 5 years from the date of loss at that point, and you probably have a whole host of other legal issues, and maybe that accounts for 1% of the claims or less that you'll be dealing with as an insurance carrier. So you deal with those on a case-by-case basis. But hopefully that addressed the insured duties portion of this bill, which is again, a well-intended, I think, portion of the bill. But if there is going to be a glitch bill, Lisa, we may have to dissect that language a little bit more, particularly as it relates to ACV and RCV.
I see other questions there, Tom. I see one dealing with, you know, does this affect lawsuits before or after July 1? It would be after July 1, right? There's no retroactivity here.
No retroactivity, and I don't even think it's going to affect anything for quite a while. Because a lot of the stuff that's in this language is not procedural in nature, it's probably substantive. And again, for anyone who was listening earlier, or if you dropped off or whatever, the existing policies are going to conflict with a lot of the language in this bill. So in a challenge between a statute and a contract, the contract language wins out in a legal setting for the most part. And you know, it's going to be a race to the Office of Insurance Regulation, I feel, to get a lot of this stuff into policies. And I don't know anymore. That used to be a part of my life, but it is no longer a part of my life. So I don't know how quickly that happens any longer.
Take a look at some of the other questions, Tom, and while you're doing that, I want to encourage those that are still with us, and I still see there's several that are. When I see a vacuum in this industry is that we craft policy language and we submit it to OIR and we never ask our defense lawyers. And then we find out that what we crafted really didn't work well in court. So it may sound like a fundamental, but I highly recommend for those of you that are in charge of policy form language, particularly with respect to this bill, ask your defense lawyer, am I writing it correctly? Unfortunately, our regulators probably will not be putting out template language. In a perfect world, that'd be nice because the statute's pretty clear, but I think we're going to be on our own. Other questions, Tom, that you see in the list?
I wanted to address one, Lisa. There's one about the insured duty make an offer or require to mediate. That's what it does seem to say. So it does seem to suggest that you don't have to do both. You just have to do one. But again, it's a cost. It's a cost that I don't necessarily know if that's fair to an insurance carrier who has made what it feels is a valid or fair coverage determination. There was another question that asked whether or not the original pre-suit offer could be re-offered, and would that satisfy the offer in response to the notice of intent to litigate. I think the answer to the question to that, reading the statute, is yes. You know, nobody's obviously litigated it, so I can't say that with certainty, but it seems like the answer is yes. I guess the concern would be more in those instances where an undisputed payment has been made. And where a payment has been issued and then there is a request for additional money beyond the payment. What is your obligation at that point? It seems like the statute's saying the obligation is to offer more money or go to mediation. It doesn't necessarily seem fair. It seems to require every single claim to that is not a denied claim to potentially result in some kind of a pre-suit mediation or some kind of an additional offer by the carrier. There may be instances where the carrier just believes it doesn't owe any more money. It's not going to offer any more money. And under those, in those instances, until something is changed, or if something is not changed in the statute, or if courts uphold that provision, then really you're just going to have to make nominal offers. And you're going to have to say, look, this is what my offer is for purposes of satisfying the statute. And sure, I'm just checking a box, but ultimately I don't think you're entitled to any more money. And if you're going to sue me, I guess you're going to sue me, and then you deal with it down the road. It's not a foolproof statute. It doesn't solve all of the problems. In fact, it may create some additional ones. But I think from my perspective, when I look at this, the two biggest benefits to me when I look at this as somebody who's litigating these all day long and fighting it is, number one, it should create a circumstance where you're getting more reasonable demands as an insurance carrier, at least pre-suit. And I think that that's actually a really good thing. Because if that's the case, then you may be able to resolve some of these claims that normally you couldn't. And that's a really big one. And then the second one is the notice of intent at least gives you 10 days to go back and double check to see if maybe you missed something. And if you did, you fix it. If you didn't, then you make whatever offer you make, and you go and you fight another day.
Yeah, and they're totally agreed. And also, I think there is going to be a challenge to get a lot of this stuff up and running, because there is an argument and a valid argument that at the very least the notice of intent to litigate requirement and the notice requirements in the statute could take effect as a procedural aspect of this bill on July 1, 2021. So hopefully we start seeing those on the insurance side sooner than later, and we can start hashing this stuff out sooner than later.
Any other questions? Any other questions you see, Tom?
I didn't see anything. A couple of questions just about the program. First of all, thanks to everyone who's still on and everyone who attended. The recording will be provided by Lisa to everyone in a link once we figure out how to do that. And Lisa will get it out to everybody. But there is a recording of this for anyone who wants to revisit it. Consequently, Mike and I answer questions from clients all day long. And we also answer questions from adjusters on both sides about who we do not represent. So if anyone is a participant in this meeting that has a question, our email addresses are in the public domain. Mine is tom@zinoberdiana.com. Mike's is michael@zinoberdiana.com. And also somebody asked me to share the fee example. I can do that very easily, but I'm going to double check my math before I do that. So thanks everyone for attending.
Thank you. Mike, any closing remarks?
No, other than, I think it's a work in progress. I think everybody's going to have their own kind of battles with this, but I do think that it's probably good. At the end of the day, I think it does try to attempt to solve some of the problems we've been running into. And, if I think anybody on the claim side who has questions or sees issues, I don't think that they should be bashful about reaching out to your counsel and your attorneys to ask them what their thoughts are. And you may get differing opinions, and that doesn't mean that anybody's right or wrong. Some of the things we said today, some people may disagree with, and maybe ultimately they're proven correct. But I think that there are, there are things in here that are not quite black and white and totally clear, and you should go seek some kind of counsel for somebody on some of these questions, because ultimately I think it can ultimately impact how you handle your claims and how ultimately they turn out in the end.
I'm grateful to my colleagues, Mike and Tom, and so many of you are sending us great accolades about this particular webinar. If you have an interest in hearing from others in the marketplace, I love to do this kind of thing, convene people, have people talk, bounce ideas back and forth, even with plaintiff lawyers and public adjusters. We're all in this together in one sense or the other, all for the good of the consumer. So without further ado, we're going to sign off. Y'all know how to reach me at Lisa Miller at lisamillerassociates.com. And of course, Tom and Mike are at your beck and call as well. Thanks again. And we're saying sayonara, or as they say in California, ciao.
Take care.
Bye-bye.
Take care.